Now, another concept we have is remoteness of damage. So what is remoteness of damage? Do you remember anything from your, might be LL.B days? Remoteness of damage, what is that? Remoteness of damage means the damages we know, right? That payment of compensation to repair the loss or harm suffered. What is remoteness of damage? That means how far or how closely is the act or omission related to the loss suffered. Okay, for what all losses or damages we can ask for compensation. Okay, when we talk about violation of a legal right of parties because of act or omission, it can have a lot of consequences. Okay, we say that it can lead to one consequence that will lead to further consequences further. It's like a never ending chain. Okay, if we start relating it, there will be like every single situation we can try to relate, but that's not possible, right? We cannot make one person liable for all those different situations, because he would otherwise end up paying compensation for his entire lifetime. So remoteness of damage basically tells us how can we fix it, like how can we like keep it limited. For what all cases we can ask the person to pay compensation, and for what all cases we can ask that okay, fine, it's like too remote, it's not closely related or associated with the act or omission. Okay, so remoteness of damage basically tells us that only that for all those consequences plus consequences of consequences for this entire chain, it's not possible that we make the person liable. So for some situations only we can make a person liable. For what all situations, how to decide it? For that, we have two different tests of remoteness. Okay, there are two tests which we can apply, and we can try to fix the liabilities of parties. First one being the test of reasonable foresight. Foresight as in what we can foresee when we are doing something. It even applies to us, right? Whatever we are doing, even if maybe we are simply typing a message to our friend, there also we will think about the consequences, right? Sometimes we think like, okay, should I write it like this or should I write it like that? Okay, if I want to might be cancel a plan that I had with a friend of mine, I will be like, okay, should I write it this way or write it that way? That means we always think about the outcome of a certain thing when we are doing it. And same thing is expected by law also from us, that when we are doing something, we should analyze it, right? That what might be the consequences. So when we say test of reasonable foresight, that means when I was doing a certain thing, when I was being negligent, when I was doing some wrongful act, what all situations I could foresee, that if I'm driving negligently, I can definitely foresee that it will create risk or it would endanger life of the people around me, life of other people on the road. That is something that I can reasonably foresee. Like a normal person with his imagination, what all things he can think about. It's not like a stupid person or like someone who is having extraordinary imaginary skills. No, a normal person, what will he think of? A normal person will think that it will create risk for the public. I may hit someone, a person may die, a person may suffer loss. So for those situations, I can be held liable. If I am driving negligently and there is some accident taking place, a person suffers loss. So test of reasonable foresight basically tells us that we can fix the extent of liability by saying, is the consequence something that I could foresee before doing it or not? Okay, take for example, if I was driving very negligently and there is some accident taking place, a person suffered injury. I will be held liable to pay compensation to that person, maybe to pay his medical bills, because that is something which I could foresee. But maybe at the same time, just next to the road, there was one apartment where there was a pregnant lady standing in her balcony and just seeing around. And she saw from that balcony, she saw there is this accident taking place. And she had undergone nervous shock and she fainted there. She was admitted in the hospital because her situation was so critical. Her baby died. In that case, I cannot be held liable for that situation because it is something which I could not foresee, or it's not directly related to it, right? Because she was very much sensitive over there. So I cannot be held liable for it as I could not foresee it. If I'm driving negligently, I would not think that someone from her apartment's balcony would be looking at me, seeing the accident, she would go through nervous shock and then her baby would die, this, that. I cannot foresee that. That means I cannot be held liable for it. But yes, I will be held liable for this damage suffered by the person who was a victim in the accident taking place. Okay, that's the first test, how we can decide the amount of compensation. Second one being test of directness. Directness is a direct outcome or result of my act or omission or not. If I have done something wrong, if I was driving negligently, was it directly because of my act or not? Or is it that there were some other elements coming in between? Okay, was it because the person was also driving negligently? Was it because the person was talking on phone and he was simply crossing the road without saying? What was the situation like? Was it directly because of my thing, or some other factors also contributed there? Okay, and accordingly, in the test of directness, it is said that we will try to analyze those situations and after that we will fix the compensation. If because of my because of my act or omission directly person has suffered loss, their person will be held liable. Like I will be held liable to pay the compensation. But if it was not because of my act or omission, but some other factors also contributed there, I cannot be solely held responsible for it. Okay, that is nothing but test of directness, which can be applied by court, that whatever is directly related or associated with my act or omission, for those only I should be held liable or answerable, not for every consequence of consequences. That entire chain should not be there. Some other intervening factor should not come in between. Okay. Is it clear? Calculation of damage in the remedies and how it will be decided. Is this part clear? So payment of damages, because it's the most common type of remedy or relief, right? So it is accordingly it needs to be decided. Like it's most common that we would see. After that we will see injunction orders being passed. And then in certain cases, persons can ask for restitution of their property as well, whether movable or immovable. Okay. So you can note down these points as well, and you can go through them once, what all judicial as well as extrajudicial remedies we have available with us.